The reason why I bring this up is because we can hardly remember any cases, aside the case, the celebrated case of Bola Ahmed Tinubu, who appeared before the Code of Conduct Tribunal. Not many people can remember many other cases or any other cases that were brought before the Code of Conduct Tribunal, or that even the Code of Conduct Tribunal instituted against public office holders. It's only in 1 or 2 cases that we've seen that, and this is possibly the first case we're seeing against a public office holder in this dispensation, when we know that almost all public office holders, including civil servants, are required to fill the Code of Conduct Bureau forms. It would seem that the Bureau has been so powerless that, you know, it chooses not to exercise its power. Or what do you think could be responsible for that? For that silence that we seem to get from it?
Institutions work in an environment. Take the judiciary, and I will answer your question directly. Take judiciary, for example. If the judicial neighborhood is reeking of corruption and is not supportive of the independence of the judiciary, not supportive of adherence to the rule of law, not supportive of the judiciary doing its best at the third arm of government, the likelihood is that you are going to have a judiciary that is not performing or underperforming. Same thing goes for other institutions. If you have a permissive environment, and institutions are meant to work in this permissive environment, what you have is that the institution will not function. So, if you ask the question why the Code of Conduct Bureau or Tribunal specifically has not been functioning, handling cases, in spite of the patent cases that ought to have been brought before it, I will tell you that, yes, the infirmity of this institution is because of the political environment in which we've had. So, if you now have a political environment that is fighting corruption, I think that it behoves for us. We have a duty to encourage that. And so, if it is a Senate president, for example, that is being brought, we can then ask, what of the Speaker? What of a governor? What of a vice president? What of even a president? Okay, I think that that's how we can strengthen institutions, rather than saying, no, don't go there. It's witch hunt and all that. I don't buy that idea.
And perhaps you're already asking that question. I mean, the Senate president will most likely be asking, well, this was in your purview, you knew about this all along. Why are you just bringing this case up one? And then he possibly cannot be the only one. You know, that the Code of Conduct Bureau will be investigated.
You know, Melkwe, there's something called, as a defense in civil procedure, laches and acquiescence. You know, with all those things, delay defeats equity, aids the vigilant and not the indolent. You have to come to court, your matter is statute bad and all that. In civil procedure, all these things are there. As a matter of fact, even in criminal law, there are certain cases that have statutory bar. For example, under the Customs Act, there are certain things that can't go beyond 6 months and so on and so forth, that you can't prosecute them, you know, if you exceed that period. I'm saying that all these fine arguments, why now? Why me? Why this time? All those things should be taken before the tribunal to knock out discharge. That's the rule of law. I know the idea of encouraging, of allowing courts of coordinate jurisdiction. And that's if you are to be charitable, because I've argued here that the Code of Conduct Tribunal is a special tribunal. So the idea of allowing a court of coordinate to interfere in the proceedings of other courts, which in itself also amounts to subverting the independence of the judiciary. When a court is using its own process to interfere, not only interfere, truncate the proceeding of another tribunal or court, that's interference. So the idea should be jettisoned. And that's why I've called that, look, because what happened in 1999? Abacha, yes, Abacha, felt uncomfortable with the judiciary. And he set up a panel called the Esho panel, headed by the jurist, Esho, Kawde Esho, of blessed memory, to look at the conduct, and some judges' names were collated. But that report was there. Abacha wouldn't act on it. Perhaps for a reason. But Obasanjo came in 1999 and said, let's look at this report. And it was reviewed. And some judges, to 10, were sent off the judiciary immediately as a starter. And between that time and now, several judges, including Court of Appeal judges, at least 2 of them, have been given the boot as a result of election petition, related bribery matter. So I am saying that now that we've gone through all these, we are here in this quote-unquote new era. That kind of grand commission is required.
And your argument is, Mr. Ogunye, hold on. And your argument is that even if you have some kind of news or fears about some of these people who are about to bring you before justice, something untoward, you can as well bring it before them when you get there.
You will raise that objection there. That's what I'm saying. I'll tell you something. Our jurisdiction is so permissive. And I'm not railing against judges alone, even lawyers. Even for lawyers, why do you think Ibori's lawyer is in jail right now? If we were to be in Nigeria, he would just say, I'm just doing my job. He won't be in jail. I'm telling you, there are certain things you can't do in Senate climes. It's because of what we are. I'm not just talking about judges alone. I'm even talking about lawyers. Because you see, when they bring a matter before you, say, sorry, no, it has professional ethics implication for me as a lawyer. So what I can do for you is that, yes, this charge is improper. No sitting attorney general, blah, 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 blah. We'll go and raise it there. That is what a lawyer who is conscious of his obligation to the preservation of the rule of law should do.
Mr. Ogunye, finally, sorry, Mr. Ogunye, the meeting for 21st of September, what do you think should be done?
Unfortunately, I'm not the Attorney General.
Okay.
If I had the Attorney General, this may sound, I'm familiar with what it says. And I can tell you, if I had to be the Attorney General, the arraignment should be taking place today in that Code of Conduct Tribunal, because it's a special court and the Federal High Court has no supervisory jurisdiction over that court. It has no appellate jurisdiction over it.
Mr. Ogunye, thank you for coming in, sir.
Yes, my pleasure.
We'll take a moment and we'll come back to look at another matter. This time, stay with us.